Let me introduce now the first presenter, which is Mrs. Amina McNoon, Director, Legal Services, the Betting, Gaming and Lotteries Commission. Amina McNoon joined the Betting, Gaming and Lotteries Commission in September 2009. She's an attorney at law and a non-practicing solicitor of the Supreme Court of England and Wales. Mrs. McNoon completed her Bachelor of Laws at the University College of London, qualified and practiced as a solicitor in the UK before relocating to Jamaica with her husband and children. Having been called to the bar in Jamaica, she worked in the litigation department of the Attorney General's Chambers for over 4 years, during which time she also was seconded to the Assets Recovery Agency, where she commenced the first civil recovery and criminal forfeiture claims under the Proceeds of Crime Act. Mrs. McNoon is also a part-time tutor at the Norman Manley Law School and has made presentations at a variety of legal seminars and published articles in the Jambar Journal and West Indies Law Journal. She has recently been awarded a Master's in Internet Law and Policy from the University of Strathclyde in Glasgow, during which time she researched and wrote a dissertation entitled Establishing an Effective Regulatory Framework for Internet Gambling, the Case for Jamaica. Let us welcome Mrs. McNoon to the podium.
The Honourable Minister Horace Daly, Minister without portfolio in the Ministry of Finance. Deputy Financial Secretary, Mrs. Anne-Marie Roden. Chairman of the Betting, Gaming and Lotteries Commission, Mr. Gary Peart. Chairman of the Jamaica Racing Commission, Mr. Linton Walters. Chairman of the Casino Gaming Commission, Mr. Walter Scott, Queen's Counsel. President and CEO of Supreme Ventures Limited, Mr. Brian George. Executive Director of the Betting, Gaming and Lotteries Commission, Mr. Andral Jack Shirley. Chief Executive Officer of Caymanas Track Limited, Mr. Cedric Stewart. Assistant Director of Public Prosecutions, Mrs. Andrea Martin Swaby. Licensees and stakeholders in the gaming industry, other distinguished guests, members of the media, and ladies and gentlemen, a very good morning to you all. We are gathered here in this morning's session to witness the union of a rather unlikely couple. She is a dynamic industry, global in nature, constantly reinventing herself and leveraging cutting-edge information communications technology to a great extent. She is Ms. Gaming. He is a rather sluggardly companion, rather cumbersome and traditional, set in his ways and slow to change. He is Mr. Law. If anyone present knows of any reason why these two should not be joined, then they should hold their peace. For joined together they must. Since it is absolutely essential that the BGLC, Betting, Gaming and Lotteries Commission, the regulatory body charged with the responsibility of regulating the operation and conduct of the gaming industry on the island of Jamaica, should be adequately equipped to deal with the modern-day realities of that industry. The only way in which the BGLC can discharge its functions effectively is if Mr. Law becomes in tune with his new companion so that he can adequately attend to her needs. Yes, indeed, although this is an unlikely match, it is one which even eHarmony would be boastful of. Therefore, without further ado, ladies and gentlemen, it is our pleasure to present to you the Betting, Gaming and Lotteries Amendment Bill of 2014. Dynamism meets tradition. Just to provide you with a little bit of background to the bill, the Betting, Gaming and Lotteries Act dates back to 1965 and followed for the most part the precedent of the UK Betting, Gaming and Lotteries Act of 1963. With the exception of some piecemeal amendments, the BGLA did not sustain any substantial review until 2010. The Betting, Gaming and Lotteries Amendment Act of 2010 went a long way in bringing the regulatory framework into the 21st century. However, some important gaps remained. The Betting, Gaming and Lotteries Amendment Bill of 2014 seeks to strengthen and improve the regulatory oversight of the BGLC, rectify gaps in the Act which remained after the 2010 amendments, and improve the collection and management of revenue. The bill was on Tuesday passed by the House of Representatives and is expected to be laid before the Senate imminently. And whilst the BGLC anticipates that the bill will enable it in its mission to be a world-class gaming regulator and facilitator, it is recognized that as soon as the ink is dry on the Governor-General's assent, Ms. Gaming will reinvent herself again, and old Mr. Law will have to make haste behind her to try and keep up. My aim in this session is to sensitize you to some of the main changes brought about by the bill, and I intend to do so under the auspices of the BGLC's mantra of regulating, facilitating, and enabling. So let us first talk about facilitating and enabling. The bill facilitates the expansion of outlets, including mobile outlets, for the sale of sports betting, and it also introduces a licensing regime for lottery sales outlets. The bill introduces two new entities, being a sports betting outlet, which is defined to mean any premises or such other type of location, conveyance, or medium as may be approved by the Commission for the purposes of conducting the business of sports betting. And a lottery sales outlet, meaning any premises or such other type of location, conveyance, or medium as may be approved by the Commission, which is used by a licensed lottery agent to receive or negotiate bets as agent of a lottery promoter, and which is licensed by the Commission. The expansion of sports betting outlets to beyond the confines of the licensed betting office or betting or gaming lounges is intended to tap into the large market for sports betting, which the BGLC research suggests exists in Jamaica. So a player will be able to purchase a sports bet at the same or similar locations to where they can currently purchase lottery tickets. These new definitions were crafted to take account of the fact that the industry operators are contemplating new types of sales outlets, not just your traditional brick and mortar establishments, but also conveyances such as mobile units, which will enable them to extend their market reach. The concept of a mobile unit has particular import in the realm of lottery, as the BGLC anticipates it will enable the legal lottery operator to compete with the illegal lottery operators who service the remote areas of the island whilst leveraging the legal lottery operator's product, in particular cash pot. Accompanying the bill will be the telephone betting regulations, which facilitate bookmakers taking bets over landline and mobile telephones and also via text. These regulations provide the regulatory superstructure for the enabling provisions in the 2010 amendments, and are also intended to capture the illegal market in telephone and mobile sports betting, which the Commission has anecdotal evidence takes place on a large scale in Jamaica. Important new definitions include telephone betting, which means electronic betting in which a telecommunications network or system is used to effect bets by voice or text messages via either fixed telephone line or mobile phone, or such other means approved by the Commission utilizing a telecommunications network. And text betting means placing a bet by text messages using a telecommunications network transmitted using mobile phones, pagers, or other devices, such messages to be sent through a messaging service approved by the Commission, which includes, but is not limited to, SMS. You will note from my added emphasis that the definitions have been drafted widely enough to capture any new mediums for telephone and text betting, which may not yet be in contemplation, but may appear on the market in the future when Miss Gaming decides to up her game again. The bill also provides for the grandfathered gaming lounges, namely those entities which were licensed to operate 20 or more gaming machines on or before June 22, 2010, to make an application to increase the number of machines on their premises to a maximum of 225, if they apply by March 31, 2019. By way of reminder, a machine is now defined as a seat by virtue of the 2010 amendments. A new section, 43C, provides for the licensing of technical service providers of the support services ancillary to any betting, gaming, and lottery activity. Technical services includes developing, testing, selling, supplying, installing, adapting, configuring, repairing, maintaining, downloading, or providing consulting services in relation to any hardware or software for use in connection with any betting, gaming, or lottery activity. It also includes processing electronic transactions or providing facilities for the processing of electronic transactions and providing networking and security facilities for the conduct of any betting, gaming, or lottery activity. The new section 43C does fall under the theme of regulating, since it is crucial that the BGLC is empowered to license and regulate these types of support services in the 21st century technology-intensive gaming industry, so as to ensure the integrity of the games and the protection of the revenue of its stakeholders. Nevertheless, it is also an important facilitating provision, since it paves the way for an entirely new legal market for these service providers in Jamaica. Moving on to the business of regulating. An important aspect of regulating is ensuring the probity of the persons employed in the industry. The bill requires the licensing of prescribed premises workers, which are defined as persons employed in any prescribed premises who receive or negotiate bets on gaming machines, or who are involved in the operation of gaming machines on those premises. Also required is the licensing of bookmakers, bet writers, and the terminal operators both at the racetrack and off-track betting parlors. Previously, there was no requirement in the legislation for these persons to be licensed by the BGLC. However, in accordance with international best practices, these persons will now be required to obtain a license from the BGLC, which will involve satisfying the fit and proper criteria for licensees. A further regulatory feature is the formalities for the decommissioning, recommissioning, and repairs to gaming machines. To protect the integrity of licensed gaming machines, licensees must obtain the permission of the BGLC before commencing any of these activities, and an officer of the BGLC will be dispatched to oversee the conduct of these activities, which involves the breaking of the BGLC protective seal on the machine's motherboard, which would ordinarily render the machine vulnerable to tampering. The BGLC will also be able to charge a fee to cover its expenses in policing this aspect of licensees' operations. A necessary prerequisite to an effective regulatory regime is that the regulator has the necessary resources to perform its duties. As such, the bill provides for the increase in revenue stream to the BGLC and other departments of government through a variety of measures. Firstly, the introduction of licensing fees where none existed previously. Licensing fees will now be payable for prescribed premises workers, bet writers and terminal operators, lottery agents, sports betting and lottery sales outlets, and off-track betting parlor agents and premises. The revenue stream will also be enhanced through increases in existing fees and taxes. There is an increase in licensing fees and levies for gaming machines and premises. All slot machines have been moved from the flat rate levy into the gross profits tax regime, and the lottery tax has been increased to 25% of gross weekly revenue for the declared lottery, and to 20% in the case of daily numbers games and the instant lotteries. Before persons begin to get alarmed, please note that many of these fees and taxes have already been implemented by virtue of provisional tax orders and regulations, and as such the bill merely seeks to make them permanent. There are no additional increases beyond the levels introduced in April of 2013. And of course, the ability of the BGLC to facilitate and enable new business models itself creates new revenue streams for government. Although the BGLC desires, through its facilitating role, to encourage legality and compliance by industry players, as the regulator, it must also be adequately equipped to deal with offenders and those persons who are determined to operate outside of the parameters of the law. It must therefore have effective enforcement capabilities. A major enforcement tool introduced by the bill is the fixed penalty notice system. The 2010 amendments created the enabling provisions for this system, and this bill, through its 7th and 8th schedules, designates certain offences under the Act as fixed penalty offences, for which a fixed penalty notice may be issued by the Commission's officers or other authorised persons. The fixed penalty notice operates in a similar fashion to the traffic ticket system. When an officer of the Commission observes a breach of the legislation, he is empowered to issue a fixed penalty notice, which the offender has the choice of paying within a certain time frame or contesting at the resident magistrate court level. Of course, the levels at which the fixed penalties are pitched are designed to be a deterrent to repeat offenders, as well as to provide an incentive to offenders to pay the penalty rather than risk going to court and losing, since the magistrate can then impose much higher penalties. And there is also the shame factor of being brought before the court. Some examples of the range of offences which can trigger fixed penalties are: under Section 44A, operating a gaming machine without being licensed. That attracts a fixed penalty of $200,000 and a maximum fine by the magistrate of $500,000, and in default of payment thereof, to imprisonment for a term not exceeding 6 months. Section 20C, which creates the offence of permitting a minor to bet, negotiate, or participate in any betting, gaming, or lottery activity, or to be in a room where gaming machines are located, attracts a fixed penalty of $500,000. And if you were to contest that at court, the magistrate can impose a maximum of $1 million in fines or imprisonment not exceeding 3 months. Section 38, subsection 3, creates the offence of allowing premises to be used for unlawful gaming or making the premises available to any person by whom an offence in connection with gaming has been committed. Fixed penalty for this offence is $1 million, and the maximum fine that can be imposed by the magistrate is $2 million, or imprisonment for a term not exceeding 2 years with or without hard labour. And so, in conclusion, the Betting, Gaming and Lotteries Amendment Bill of 2014 does place the BGLC in a stronger position to meet its mandate under the Act and its mantra of regulating, facilitating and enabling. Nevertheless, the BGLC is conscious of the realities of the industry which it regulates, and whilst it celebrates the union of Ms. Gaming Industry and Mr. Law, it remains conscious of the fact that the honeymoon period may be short-lived, as she will inevitably live up to her dynamic nature and move forward apace. Rest assured, therefore, that the BGLC is preparing for this eventuality since, as part of the full legislative merger with the Jamaica Racing Commission Act, it plans a complete overhaul of its legislation to a model which is more responsive to the dynamics of the industry. Thank you.